Good morning. Today is Thursday, January 15th, 2026, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Brandt,
Aye, here.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Here.
Commissioner Zettel. Here. Chair Silver.
Here. Okay, great. Well, before we begin with item number one, I just want to acknowledge our beautiful surroundings here. We are here today at City Council Chambers for the City of Chico. I want to thank Chico for hosting us today in their brand new council chambers. As you may know, the FPPC occasionally will host remote meetings around the state of California to give Californians the opportunity to engage with us directly in person. I think it's a great tradition. I'm glad we can keep it alive. Personally, myself, I'm honored to be the first chair to preside over a meeting in the North State. Despite being a Los Angelino, I've been coming up here my entire life, whether it's North Coast, Lake Shasta, Mount Shasta, Lassen National Park, Yuba County. It's a great spot, beautiful scenery, amazing people, proud Californians. So thank you for hosting us. I'd also like to thank Assemblymember Gallagher for helping us put this all together. And then lastly, of course, I really want to I really want to thank FPPC staff for making this happen. It's not easy to pack everything up and go on the road. I know that. So I really appreciate you putting in those extra hours and coming up here and allowing us to engage directly with the people of California up here in the North State. So thank you so much. Let me move on to item number one, and that's going to be public comment for items not on today's agenda. Ms. Vo, do we have any public comment for items not on today's agenda? Okay. Do we have any in the room? No? Okay.
Yes, we do. Yes, we do.
Okay, my apologies. I meant in room comment. We'll move on to remote comment. Go ahead.
Thank you. Good morning, Chairman Silver and Commissioners. My name is Connie McCormick, a 29-year resident of Whittier, California, and former LA County Registrar Recorder County Clerk, now retired. I've sent you a letter requesting expediting the FPPC's ongoing conflict of interest investigation of Whittier's mayor, Joe Vinatieri. The city of Whittier will hold an election on April 14th for mayor and council districts 2 and 4. Mayor Vinatieri, an incumbent on the Whittier City Council for the past 20 years and citywide mayor since 2016, is again seeking re-election. A cloud of controversy hangs over his re-election campaign due to the FPPC's investigation of a sworn complaint of conflict of interest against him, case number 2024-00927. I filed that sworn complaint on June 17, 2024. The FPPC Enforcement Division opened the investigation on September 10, 2024. The sworn complaint alleges that Mayor Vinatieri did not recuse himself from voting on 2 city council agenda items on the controversial $20 million Uptown Whittier Greenleaf Avenue Promenade Plan, despite owning a restaurant located within the project area. The background and evidence substantiating the allegation is included in the letter to you. The Whittier City Council voted on December 12, 2023 to approve a promenade design option that removes all the mature shady tree canopy on 3 blocks of Greenleaf Avenue in the heart of Uptown Whittier. Their mid-December vote evoked public outrage when residents learned about it in January 2024. As described in the sworn complaint, quote, the strength of the public outcry is reflected by 4,010 signatures on a petition to save our trees in Uptown Whittier. Over the past 2 years, public outrage has intensified as that petition now has 8,079 signatures on it. Additionally, the Whittier Conservancy filed a lawsuit alleging violation of state CEQA environmental law and City of Whittier ordinances. That lawsuit is scheduled for trial next month in LA County Superior Court. On several occasions since the FPPC opened this case, I contacted the assigned political reform consultant to ask for an update, including asking to increase the pace of the investigation. As commissioners, I'm bringing the timing of this matter to your personal attention because In my experience when serving as LA County Registrar Recorder County Clerk, when highly sensitive issues arose, I was occasionally frustrated that staff had not brought the matter to my attention for resolution before it erupted. This ongoing tree controversy is a key issue in the campaign for Whittier mayor in the upcoming April 14th city election. Completion of this FPPC investigation prior to the election would be informative for Whittier voters and should be welcomed by Mayor Vinatieri as well in order to finalize this matter. Thank you for your consideration and for your service to California.
Thank you for your comment. Do we have any additional public comment for item number 1? No? Okay, then why don't we, unless commissioners have comments or questions, why don't we move on to item number 2, and that's going to be approval of the November 2025 commission meeting minutes. Do any commissioners have suggested edits, changes, questions related to the meeting minutes?
Motion to approve the November 25th commission meeting.
Second.
Do we have any public comment? No. Okay, Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel. Aye. Chair Silver.
Aye.
Motion passes.
Okay, let's move on to our consent calendar, and that's going to be items 3 and 4. We're going to welcome our Chief of Enforcement up to the podium today. That's going to be Chief of Enforcement Kendall Bonebrake. Good morning, Ms. Bonebrake. While we figure that out, are there any items on the consent calendar the commissioners would like to discuss or potentially pull from the consent calendar? Commissioner Zettel?
I have a quick question, if I may, on the first consent item. The cases that you use to the comparables.
I think we should pull this because I want to pull this item.
Okay.
Okay, then why don't we consider each item separately? So we'll pull essentially 3 and 4 from the consent calendar and take them up separately.
Can move to,
Excellent. I don't
Approve.
think we need to make a motion.
oh, okay.
Yeah. So why don't we start with item number 3, and I'll let Commissioner Zettel, if you'd like to start with your questions.
Yes, I was just concerned that the comparables had actually utilized mitigation circumstances, and none of them used the full eligible fine. What was the difference in this case? Because there was never any prior history of violations. And
Yes, so, sorry. The difference in this case was the dollar value. Here you have a $500,000 contribution that was made in the name of another. So you had both that violation as well as the intermediary who did not disclose that they were making that contribution as an intermediary. And it was a substantial contribution, $500,000.
my other concern was that on one of the cases that were previously adjudicated, there were 14 counts of use of intermediaries,
Correct.
10 counts of violations.
That is accurate. And in those cases, there were actually 14 separate violations that they reduced for settlement to 10. Here, we only had one violation. And therefore, the one violation, the penalty maximum was the $5,000.
But the other one, refresh my memory, with the 10 counts was 5,000 as well.
You are correct, yes.
Commissioner Brandt?
So I kind of have the opposite concern. I read this one about the LLC and Mr. Kruger, and I was just appalled. And because of the amount of the money, I mean, campaign election deception, and the fact that they did it, quickly and all that, and it kind of helps. This is the kind of situation that helps those who want to destroy public confidence in elections. This is the kind of story that helps them, that contributes to that wants to undermine public confidence in elections. And there is a lot of that discussion these days. someone who can afford $500,000, and this is not, oh, I'll put 10,000. I mean, 10,000 is a significant amount for a lot of people in this country, in this state, but $500,000 to just sneak it in, it just suggests that, you know, that kind of level suggests that elections are for sale. You know, we can just hide it. We don't have to tell you who it is. We'll just put in $500,000. That's what really, so I support that, doing as much punishment as we can. And I'm going to vote for the stipulation, but I think we need to make clear to Californians and actually to all Americans that FPPC is standing up for you, is standing up for free and fair elections. We have free and fair elections. And that's critical for Californians to understand. It's critical for all, because there are those in Washington, D.C. who say, oh, it's all a sham election in California. That's why, you know, anyway, won't go there too far, but this is the situation. This is the kind of situation where someone contributes $500,000 to a campaign, and granted, they lost, but still, $500,000 is huge, and we can't let this. We need to be out there talking about this one as an example to say FPPC is standing guard, is on duty. We're going to make sure that we have free and fair elections in California.
I certainly agree with that sentiment. Great comments by both commissioners. I have one question in terms of remedies in these types of violations, or we have alleged violations of campaign money laundering. Are these the sort of things that we share with law enforcement? Do we flag these for district attorneys, for the Attorney General's office? Because I know, obviously, we are limited in the amount of fines that we can bring per violation. And really, fines versus jail time is really a limit in terms of the impact of that deterrence. So I think if people really understand that there's a risk of criminal liability as well, it could really deter this sort of egregious conduct that Commissioner Brandt pointed out.
Yes, and since I've been here for the last 4 months, that's really what I can speak to. We have worked with law enforcement and referred things to law enforcement when we felt appropriate. Director West, if you have questions about prior history, may be able to answer, but definitely in the last 4 months, we have worked closely with law enforcement and referred to law enforcement when appropriate.
Excellent, thank you. Executive Director West?
Sure, I can add to that. We actually have an automatic referral program, as well as working hand in hand with law enforcement. We give technical support as well as behind the scenes. Sometimes you guys will see a case and you're like, why isn't this case ever settling? Because there's a criminal law enforcement going and we can't tell you. So there's always that going on. But for cash contributions, laundering source, laundering intermediaries, anonymous contributions, sender identification, commingling of campaign funds, conflicts of interest, mass mailings at public expense, and gift limits, we have an automatic referral program once we identify those violations to the Attorney General or the appropriate DA.
Commissioner Wilson?
Yeah, thank you, Executive Director West, for that information, and also our Chief of Enforcement. But the question is, if an item is, or a matter is referred to for a criminal investigation, does that mean that the FPPC is no longer involved? Or is there ever a situation where there are parallel procedures in place where the FPPC is looking into the matter as well as, local prosecutors, for example?
It definitely depends on the type of violation. So if there's something that has violations of the act that we could exclusively do, then we try to make sure that we're doing a parallel investigation so that we can prosecute our violations and they can prosecute theirs. There's also times when we're included in the plea for the criminal violations. And so then that way the violations of the act are addressed that way, and that money then goes into the general fund. There's times where we do a hand-in-hand investigation with a local ethics commission. And so there's some local ethics violations as well as state violations. So you'll have dual stipulations being presented to different commissions. So it varies depending on what type of violation it is.
Thank you.
As far as this stipulation goes, I certainly support it. We're pursuing maximum fines for this serious violation. The staff did an excellent job working this case up, arriving at a settlement. I don't want to get in the middle of that, especially given the circumstances laid out in the stipulation. I'm going to ask first for public comment, and then I'm going to make a motion. Do we have any
Second.
public comment?
Second. Second.
So no public comment? Okay. And then we have a comment from Commissioner Wilson first.
Well, I want to just say it's important that the comments that were previously made about the seriousness of this item by Commissioner Brandt, you have, and it's in the summary of the facts, $500,000 was in the personal account of Mr. Kruger, and $15,000 fine. It's like a parking ticket. So I think this is more of a rhetorical question. Do we ever, or is there even feasible moving forward to look at having options within our regulations to say, depending on the facts, we have more latitude to be able to increase the fine. $150,000 fine would impact somebody who has $500,000 in their account. A $5,000 fine, for example, would impact someone who has maybe a couple CDs and $3,000 or $4,000 in their account. So it's more of a rhetorical question, but I think it goes to the point that Commissioner Brandt had made earlier. Thank you.
Absolutely. We are happy to enforce any direction and change in law and statute regulation that happens. We will definitely enforce it that way.
Well, I think the general sentiment here from the commission is that we consider campaign money laundering, making contributions in the name of another, to be one of, if not the most serious violation of the act. So we would expect maximum, very high level fines for those sorts of violations. Of course, considering mitigating circumstances in those cases, though. Commissioner Zittel.
Thank you. I want to make it very clear that I fully support Commissioner Brandt's comments. My question was why we didn't have any other comparables that were really comparable that we didn't mitigate.
Yes, and my understanding, looking at this, was these were the most comparable, and we chose the most comparable in this case. But definitely something we will always look at to make sure that we are choosing the comparable that is most accurately representative of the facts.
Thank you.
Great. Well, I'm going to make a motion to approve item number 3. Do I have a second?
Second.
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye.
Chair Silver,
Aye.
motion passes.
Okay, let's move on to item number 4 in the matter of County of San Benito. Because 3 was removed from the consent calendar, we're going to take this one up separately. Do any commissioners have any comments, questions on item number 4?
I'll just
Commissioner
say
Brandt?
this is another example of where we need to continue doing work on when public agencies send out mailers like this. And I'm going to support this stipulation, but
And
it's just another one
education.
where they try and do their best to just work right around. But no, this is a campaign. So that's why I just think somehow we need to deal with this issue. And as a state, it's not just us, but how do we do this? And especially as we've talked about before, when it may mean millions of dollars, and they pay $20,000 in a fine. I don't know. I don't have an answer. So I just wanted to note that it's, once again, we're dealing with a campaign mailer by a public agency.
It is certainly an important issue and sometimes a tricky issue to navigate. And I'm glad that in recent months, we've engaged with different stakeholders like Institute of Local Government, League of California Cities, to let them know, as well as I should say, Howard Jarvis Taxpayers Association, to let them know that we are looking for ways that we can be a resource to reduce this sort of activity in California. And potentially sponsor legislation or adopt regulations that make these rules clear for officials and jurisdictions to follow. I think it's worth noting that our general counsel will be presenting pretty soon, I forget what the exact date is, to ILG, the Institute of Local Government, on these specific issues. So I'm glad that we are shining a light on this important issue. Any other questions, comments from commissioners? Do we have any public comment on item number 4? No, hearing and seeing none, I'm going to move to approve item 4. Do we have a second?
Second.
Okay, Ms. Vo?
Commissioner Brandt? Commissioner
Aye.
Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Zettel?
Aye.
Chair Silver?
Aye.
Motion passes.
Okay, next we have our pre-notice defaults, items 5 through 7. Is there anything, Chief Enforcement Bonebrake, that we should know about items 5, 6, or 7? Are any of their respondents here? Have they contacted you?
So Chair Silver, there is no change in what we are pre-noticing today, but I will say that this process is working very well, and we did receive a communication from one of the respondents, and we are very hopeful that based on this process, we will not have to bring that particular one to you next month as a default, and instead as a stipulation. So we are very hopeful that this number will be reduced by the time we actually go to default. This process is working well.
Excellent. That's great. Commissioner Zettel?
Just a quick comment. It's interesting that all of these occurred with the same, the Recreation Department of LA. It's kind of like all were clueless, which gives import to what we're trying to do to inform public agencies. It was interesting.
I know we're at a very preliminary stage in terms of these case resolutions. Are you able to share any background as to why we're dealing with one specific agency here? Or is that something we would bring up later once we have a stipulation on the agenda?
So it would come up when we moved forward to either a stipulation or a default. It will outline all of the facts that will show you why we are here today.
Okay. Okay, perfect. Any other comments, questions from commissioners? Okay, do we have any public comment on the pre-notice defaults? No? Okay. Then thank you, Chief Bonebrake. Why don't we move on to item number 8, and that's going to be adoption of proposed amendments to Regulation 18361.4, probable cause proceedings. We're going to have up at the podium Senior Commission Counsel John Fizer. Good morning, Mr. Fizer.
Morning. Chair and Commissioners, if you recall, we proposed the amendments to Regulation 18361.4 3 months ago at the October meeting. I will provide a brief summary to refresh your recollection, then address the objections raised in 3 letters opposing our recommendation. To summarize our prior discussion, the Commission requested that staff present recommendations to limit delay and the completion of the probable cause proceedings. The amendments that we recommend for adoption today would accomplish this in 3 general ways. First, the amendments would remove existing provisions that provide for records production. This change will align the current process with other similar probable cause processes and more strictly adhere to the controlling statute, Government Code Section 83115.5. Second, the amendments would provide a firm deadline to conduct a probable cause hearing. Finally, the amendments would eliminate provisions regarding witnesses, hearing participation, and submission of supplemental evidence after a probable cause hearing. Probable cause is an informal process that is preliminary to formal administrative adjudication. Probable cause serves a gatekeeping function, not an adjudication function. Probable cause is a safeguard used to prevent groundless proceedings and to screen cases for further action, not to resolve charges or reach a judgment. 3 letters were submitted in opposition to the proposed amendments. I will address their grounds for opposition. The first of which is opposition to removing document production from the probable cause process. Document production has not always been a part of our probable cause proceeding. It was added to Regulation 18361.4 in 2011. Document production is irrelevant to the question at issue in a probable cause conference. And that question is whether the evidence is sufficient to lead a person of ordinary caution to entertain a strong suspicion that a violation occurred. The hearing officer's role is to evaluate the sufficiency of the summary of evidence provided by enforcement, not to weigh it against contrary documents. I have been a hearing officer for 8 years, and documents are irrelevant to my determination of probable cause. Also, in my experience, counsel for respondents never refer to documents. Document production during probable cause unnecessarily duplicates the full rights of discovery that respondents are entitled to in the Administrative Procedure Act process. By removing document production from this preliminary stage, we are not depriving respondents of due process. We are simply applying those rights to the proper venue, formal APA adjudication process that occurs after a finding of probable cause. Staff's recommendation to remove document production is based on adherence to the controlling statute, section 83115.5. This statute requires that a respondent be presented with a written summary of the evidence and informed of the right to be represented by counsel. Section 83115 does not grant respondents a right to a hearing, nor does it grant a right to document production. Therefore, respondents have no statutory right to a hearing or document production beyond enforcement's written summary of evidence. By removing provisions for record production, we are not depriving respondents of any rights. We are returning the probable cause process to its statutory intent. Under the proposed amendments, respondents retain all rights under section 83115.5. Respondents are protected by the fact that no determination of a violation and no penalty can be imposed without the full due process protections of the APA. The opposition letters assert that removing document production would deprive respondents of due process rights, but probable cause is not an adjudication. Respondents are not entitled to APA level due process at the probable cause stage because no deprivation of property or liberty occurs. Due process rights, including formal discovery, the right to an evidentiary hearing, and a neutral fact finder, are provided exclusively under the APA. Finally, the opposition letters argue that document production should not be removed from the probable cause procedure because discovery is allowed under the Federal Election Commission's probable cause procedure. The FEC's and FPPC's enforcement procedures are not comparable. FPPC enforcement involves 3 general steps: probable cause, APA adjudication with a full hearing, and judicial review in Superior Court. Under the FEC, their enforcement also involves 3 general steps: probable cause, or what they call a reason to believe, and there is a hearing at the first step of the reason to believe process. Their second step is mandatory settlement negotiations, and finally, civil litigation in U.S. District Court. Under federal law, respondents have a statutory right to a reason to believe hearing and the right to conduct discovery. Section 83115.5 provides no right to a hearing or document production other than summary of the evidence. The FEC standard is whether there is reason to believe a person has committed or is about to commit a violation. This is a much different standard than our probable cause standard. The FEC has no APA adjudication. Its hearing occurs early in the process. Our hearing occurs after a determination of probable cause. Therefore, the FEC's and FPPC's enforcement procedures are not comparable. In sum, the records production and scheduling process in the current regulation enable unnecessary delay, work, and expense for all parties. These amendments would not deprive respondents of any due process. To the contrary, they would place the probable cause proceeding in its proper place as a procedure that is preliminary to formal administrative adjudication. That concludes my initial comments. Our Chief of Enforcement, Kendall Bonebrake, and I are available to discuss any questions you might have.
Thank you, Mr. Feiser. I'm interested to hear public comment on this item, comments and questions from fellow commissioners. Before we get to that, I just want to share where I'm at on this. Just a reminder, the commission directed the legal division to draft these amendments to the regulation last year in response to what it viewed as an abuse of the current PC process that allowed for unnecessary delays that were pointed out by Mr. Pfizer that allowed findings of probable cause to come out after important dates like elections. I feel that that potential for abuse still exists and that we need to take action. Right? The people of California expect us to timely resolve complaints and cases. This is why we amended our enforcement streamline regs. This is why we created our PrEP program, which has been tremendously successful. This is why we adopted new enforcement division procedures and policies that have allowed us to significantly reduce the number of open cases that we have. I believe there's been a drop of 40% in the past 3 years. If I'm a year off, my apologies. But a significant drop. Also a drop in our average lifespan of cases. Timeliness is extremely important to the public and the FPPC. With that said, we do have to, whenever we're talking about these, taking these sorts of actions, making these sorts of changes, we have to consider the types of issues that were raised in public comment in terms of the actual or the perceived impact that those changes could have on due process, or you could describe it as fairness in these proceedings. I really appreciate all the public comment that we received from the regulated community, from the California Political Attorneys Association, from law firms of Olson Remcho, Bell McAndrews, Hilltac. I followed up with several of the authors of those letters so that I could better understand their perspective, the data, if any, that they're relying upon, share my perspective, staff perspective. And I found those conversations to be very helpful and welcoming. And I appreciate their collaboration on this. With that, given that, I think this is a good time to make ex parte disclosures really quickly. In terms of who I spoke to about this, I spoke to Casey Jenkins, who was the author of the CPAA letter, as well as Jay Carson at Nielsen Merksimer, who was co-author of that letter. I spoke with Gary Winnick at Kaufman Legal Group. I spoke with James Harrison at Olson Remcho. I spoke with Nicholas Sanders of the Political Law Group. I spoke with former FPPC Commissioner Catherine Baker, who was a staunch advocate for reform in this area. I also spoke with Bob Stern, who is a framer of the Political Reform Act. And I really appreciate getting all that feedback from folks. It's my understanding from my discussion with CPA folks that they're going to request that we delay consideration of these amendments to a later meeting. And they're requesting that delay so that they can engage further with the legal division. And hopefully we can come to a resolution that addresses the serious concerns we have in terms of potential abuse, while also recognizing some of the issues that were raised by CPAA. Of course, I would like CPA to put that request on record during public comment if that's possible, and that's the way they would like to pursue this. And I definitely want to hear from fellow commissioners if they would like to go a different direction. But I believe a delay to the March meeting would be the ideal next step for this regulation, this amendment to the regulation. With that, Commissioner Ortiz.
Thank you, Mr. Chair. I find myself conflicted between two things. The concerns raised by the letters about the person whose reputation, if you come before a hearing without the protection due process, his or her reputation is going to be impacted even before that person is found that violated. So there is that concern. The other concern is the staff time and what you're talking about, that is really takes a long time. People play games about delaying the process, and what the chair was talking about, reducing the amount of time that something takes to investigate and process. On the CPAA letter on the last page, it says, a more appropriate resolution of the matter can be required, can be reached without additional time and expense of a full administrative hearing. Do you know what they're talking about, the other solution? Have they been asked, maybe when you were talking to them?
There's nothing in the process now, but certainly that's something we could discuss. But enforcement is free to settle with respondents at any time. And I believe they do use a probable cause process to do that. They utilize that for that purpose. But there's nothing, and there's no framework for any resolution other than finding a probable cause and then APA adjudication.
I thought that when we're talking about more appropriate resolution, they were talking about maybe reaching a middle ground between their concerns and our concerns. And I don't know if that exists. Not just wondering if it's worthwhile talking to them and trying to figure out what other way, according to the letter, could be reached to resolve it.
I can speculate as to what they were referencing, but I'm going to defer to public comment. I understand we have public comment, and they can speak to it. Before we do that, Commissioner
Yes, I
Grant?
just want to I want to respond to the commissioner, but I'm going to wait hear all the public comment. I read the letters and, I think that, but because I have a definite view, but I want to hear what public comment has to say before I say anything further.
Excellent. We have public comment, Isabel? Go ahead.
Hi, can you hear me?
Yes, we can. Good morning.
All right. Good morning. Thank you, Chair Silver and Commissioners. This is Casey Jenkins. I'm speaking on behalf of the California Political Attorneys Association. I want to first thank Chair Silver, Commissioners, and staff for reading our letter and for engaging with CPAA and our members on the amendments to this regulation. At the outset, as the Chair mentioned, we would like to request that the Commission not take any action on this item today, and instead postpone the matter to a subsequent meeting so we and other interested parties can work with staff to arrive at mutually acceptable language for the amended regulation. I want to take a moment to highlight a few points from our comment letter, particularly with regard to discovery and the due process rights of respondents going through the probable cause process. Providing a fair hearing consistent with the right to due process includes providing discovery to respondents, allowing witnesses to testify, and conducting the hearing in a timeframe considerate of everyone's schedules. A probable cause hearing provides a neutral forum for the parties to identify evidentiary gaps, legal insufficiencies, and overreaching allegations before an enforcement action becomes public. As staff discussed, the current draft of the regulation would remove the provisions that allow for document production in probable cause proceedings. However, the right to due process is implicated in PC proceedings and is meaningless if respondents do not have access to the evidence against them and an opportunity to challenge it. In addition, addressing evidentiary issues at the probable cause stage is more efficient and cost-effective than forcing cases into full APA hearings. And to address Commissioner Ortiz's concern at that section of the letter, it was referring to case settlement in that scenario that's more efficient than going to a full APA hearing. This also encourages appropriate resolutions and informed settlements, which benefit everyone. So again, CPAA requests that the Commission postpone making a decision on the adoption of these amendments and take up the matter at another meeting after we've had an opportunity to work with staff to address our concerns. Thank you.
Thank you. Do we have additional public comment? Go ahead.
Good morning, Mr. Chairman and Commission members. This is Gary Winnick of the Kaufman Legal Group. First, I want to support the comments by my colleague Casey Jenkins and the sentiments expressed by her today and in the letter that was sent to the Commission on behalf of all the CPA members. I agree that this item, given its importance, would benefit from additional time so the regulated community can engage with staff to further discuss these issues and to identify where common ground can be reached. Therefore, I repeat the request that we have a postponement of this till March so that we can discuss this over with staff. I'd also like to briefly add in an additional perspective on the issue of probable cause hearings. I have personally conducted numerous probable cause hearings over the course of my career on both sides of the equation. My perspective on the probable cause proceedings is that they add great value in terms of allowing both sides to test the legal sufficiency of the evaluation of the evidence. This has the benefit to both sides, considering how their case might play out at a full administrative hearing. I have personally participated in several probable cause hearings where this took place, and even where probable cause was found, has resulted in either a closure of the case or a negotiation of the settlement that better reflects the state of the case, once again, allowing for the ability to not have to do a full administrative hearing and getting an efficient resolution. I do want to mention that staff's assertion that Respondents Counsel has not ever referred to documents is inaccurate. I can't speak for other counsel, but I know I have personally done so on the numerous occasions I have conducted probable cause hearings. To me, the current process works for both sides. On the defense side, once a respondent sees the amount of evidence against them, it can bring them to realize that further pursuit of administrative hearing is not warranted. On the enforcement side, once they see the potential vulnerabilities in their case, a process that cannot occur without having their evidence and legal theories questioned by a robust defense. This can cause a reevaluation of the enforcement posturing on the matter. And as I mentioned, I've seen this play out on several occasions. But this important process can occur without a hearing that allows the review and vetting of the applicable evidence, discovery, witnesses, and the other protections that are at issue here are really an irreplaceable part of this. As you know, and as we mentioned, administrative hearings are very expensive and time consuming for both the FPPC and for respondents. The probable cause process was put in place to facilitate having an initial review of the legal sufficiency of the case before going to a full hearing. The FPPC has its goal, an important one, the efficient processing of enforcement cases. My view, based on my experience, is that a fair probable cause process with discovery provides the respondents drive settlement of cases and a more efficient processing of cases, not the opposite. Thank you for your attention, and I again encourage you to put this item over so further discussions with staff can occur.
Thank you. Do we have additional public comment? No. Okay. Commissioner Brandt?
So I'm good with deferring, and putting this off for a bit. But if we're going to do that, then I would like to have all of us engage in giving direction so that staff understands how much they can give. Because in this case, I really strongly believe that this needs to go forward. And I think due process, let me take bits and pieces, and I may be reminded of stuff. But the arguments about due process, there are two words in that. And I work at the National Judicial College organizing courses for judges. And I've done a course where I'm not teaching, but judges are teaching judges. But, we've had the due process discussion. And it's about balancing what's due, what process is due. And in those kinds of things, the things that we teach are, you got to look at what's at risk here. When, in a criminal situation, when they're at arraignment, they're pretty serious process that's due because their liberty is at stake. They may have bail, they may variety of things along those lines. In this case, we're at the initial stages making judgments. Is the administrative officer making judgments about the sufficiency of the evidence? I don't think so. And that's why I say there's not as much process due at this stage in the brain, because the risk is they're going to have to go to investigation. They're going to have to go to potentially to a hearing, but they can make judgments about their lawyers can make judgments, for those who have lawyers, and make judgments about the sufficiency of evidence. But I'm also concerned about those who are self-represented litigants who are going to see this as a hearing and not understand that this is not the final hearing. They don't need to bring character witnesses and all those kinds of things. This is not a trial. And so that's why I think we have a duty as the agency to move this along, to move enforcement along, because part of our duty is not just to, yes, it's to ensure due process that is due, but it's also to the people of California. We need to enforce and we need to move forward. And spending time, I mean, I understand you do summaries of the evidence, you know, they can deal with all that later. And that's why I don't want to see us giving up too much here, because I want us to focus on, we need to get these enforcement cases done. That's our job. And if there's a way to do that and adjust for giving them what they need to make some judgments, and it's not a judgment of the officer as to whether the evidence is sufficient, but if they need some, but discovery really at this point in the process, I just don't see that. I mean, I've been a litigator for 30 years and I just don't see, you know, been a lawyer for 30 years. Anyway, long story. I won't overstate, but I've been a litigator for many of those years. And I just don't see, discovery is a long process. And I just don't see it happening at the initial stage when there's a motion to dismiss. I mean, the law doesn't allow us to judge evidence basically at that point. So that's why I want to, yes, I support the, you know, deferring for a bit, but I want you to stand up for our interests in making sure enforcement actions get done timely.
Thank you. Commissioner Zettel?
Thank you. I appreciate that the staff is willing to go back into discussions regarding these things that have been on our agendas for a long time. And thank you to the chair for encouraging a little more meeting of the minds. I appreciate that. One thing that continues to trouble me, though, is reputational harm. When you deprive somebody of their reputation, you can't put, it's like toothpaste, you can't put it back in the tube. So I see that the probable cause portion is extremely important if evidence is thin. And let's talk about the people that we investigate. Many of them are local city council members. They have day jobs. So in addition to their weekly meetings, they have to provide bread and butter for their families. And so telling them, oh, you have those documents, go find them, basically. They don't have the time to go digging through old files. It's very, very, would be advantageous for them to have, here is what we're using, here is the evidence. So I really support discovery. You know, if there was a witness that actually provided something, well, maybe that witness is germane to the process. So while I appreciate that it is important for us to move these things along in a timely manner and to have some clear stops at how much time you give people, I think that it's important to give them the evidence. I think it's important that they can, if they need a witness, I'm sure that's very rare, but I don't see the harm in doing that. And I think it's important that when you present to the hearing officer, that evidence is sufficient. And I think this process helps to prove it out.
Thank you.
Well, I want to hear from everybody. I mean, I do want to respond to Commissioner Zettel because I have a different view, but.
Sure. You know, one thing that I'd point out here is, I think when this comes back in March, it's going to make a lot of sense for us to address these items one by one. So we can say, I think this should be in, this shouldn't be in, right?
Right.
There's a
And-
lot of different things that are included in this regulation: document production, witnesses, the time period in which probable cause conferences must occur, right? And they all have, you know, different considerations.
So it may be best for today for me not to respond and just, you know, we each say where we go so that staff has some clear direction and then go from there.
Commissioner Wilson?
Yes, I appreciate all the comments by fellow commissioners. Thank you, Chair Silver. But my question is, has this issue come up previously? Maybe I might ask Executive Director West, has the issue of streamlining or eliminating, or revising the probable cause proceedings come up in the past? Or is this pretty much a new issue that's been brought to the commission?
Sure, thank you. Actually, this process, as Mr. Fazer was talking about, was added in the last 10, 15 years. And sometimes the commission is more towards trying to streamline enforcement cases, and so the regulations are tweaked to try to make that process faster. But as Mr. Fazer was talking about, it's really just the summary of evidence in this very small, it's more of the speed bump part of the process is what we're talking about. And so sometimes the regulations are amended to try to make that speed bump process a little faster, and sometimes there's stuff added. I think this was added in order to try to increase settlements, to try to get the information all out there and to make things go faster. What we have found is it doesn't make things go faster. It actually slows down the process where we have to spend many hours to do a formal discovery process. And there's nothing that actually prohibits enforcement from saying, hey, especially if they're unrepresented. I mean, as I hope you guys understand, staff, it really helps out the unrepresented people because they don't know what the process is. But as Commissioner Brand pointed out, when you get a document that looks like a legal document and it says, hey, we have to have this conference, and it scares people and it makes them think that this is their hearing. It's very confusing when we put in all these formal steps for them. So yes, it makes it to where enforcement staff can say, hey, look, this is it. This is the document. You should have this. It shows that you filed this on this date and not this date. And so we don't hide the ball necessarily when it comes to these things. There's a lot of things we do voluntarily. What we're saying is having it as a formal process is what makes it difficult, because then you have to cross all the T's, dot all the I's. I think Chief Bonebreak was pointing out about the law about you can't actually provide documents as an attorney that are confidential. So we have to be extra strict and have layers of review for this. So having it as a formal process is really what we're talking about is the issue. But yeah, you're right. It's been over the past. We tinker with these. We try to make it faster. We try to make sure that it hits all the points that we're trying to do. And this is what the commission asked for. They said, hey, look, these things are being delayed. And is there anything we can do that this information gets out before the elections, before whatever? And this is what we came up with.
Well, just for clarification, so this process came about 10 to 15 years ago, something like that? Not the exact date, just approximate.
2012 was when the discovery process was put into effect. About 5 years ago, I think we took an initial stab at making the PC process more efficient. At that point, we didn't propose taking the the document production portion of it out. We added some deadlines and tried to tighten up the part of the sort of scheduling part of the process, because that's where we were seeing lots of delays happen. I think it's helped a little. I think it's helped move them along a little bit, but what we're now seeing is that really the big hangup is often this discovery process. Even though, as the numbers show in our memo, it's not that common that people request discovery, but when they do, on some of those occasions, it can really slow down the cases.
You know, well, Commissioner Brandt and Commissioner Zettel had comments, and I think the one that is probably most apropos is when Commissioner Zettel says you can't put toothpaste back in the tube. There are people who, when they hear, oh, the probable cause procedure has been amended, it's been modified, we would have to, if we make this change, explain why, when someone hears the term probable cause and that the process has been modified, that it's clearly articulated how that would impact the overall process. Because everyone is not going to follow the legalese, they're not going to read the regulations, they're not going to read the statutes. But when they hear probable cause proceedings have been changed by the FPPC, if that were to happen, we have to be able to explain why that is the case. Because not to make light of it, but when people hear the term probable cause, they think, oh, wait a minute, I'm in trouble. There's a real issue. And that's something that we need to take into account. Thank you.
Commissioner Ortiz?
Yeah, thank you. Yeah, I early on expressed my my conflicts. And one of them was expressed by Commissioner Settler when she talks about being concerned about damage to reputation. And how do you say, put the thing back in the.
Toothpaste back in the
That, yeah, that, and that will be difficult. But at the same time, understanding that we need to accelerate how we deal with cases for a long time, and that has been expressed publicly by a lot of people. That's why I go back to the CPAA letter that says that maybe another solution, maybe have them look and see before the next meeting, what is it that they're talking about that will assuage our concerns about hurting demos, reputation early on in the process.
Thank you. Do we have any additional public comment? Okay. Any additional comments, questions from commissioners? So my feeling is that we push this back to the March agenda, take additional public comment, or I should say comment, engage further with CPA and other members of the regulated community. Hoping we can get feedback in addition to what we've already received, perhaps from good government groups, Common Cause, et cetera. And then we can come back and run through each one of these items and come to a consensus that addresses the potential abuse that we see here, as well as considers the items that have been pointed out by the regulated community. So because we're not taking action today, I don't believe we need to make a motion. So I'm going to go ahead and move on to item General Counsel Bainbridge.
I'll just say you give the other commissioners an option to make a motion if they would like to. If they don't, then yes, you can just move on to the next item.
Perfect. That's helpful.
I would ask if, we haven't received anything concrete from the letters yet. It's been out there since October. So we may be waiting to see what we get from them. So if we could have, if it's not March, maybe April, if you don't mind, if it's not ready, pushing it back a month, just in case we need a little extra time.
Of course. Yeah. And if we do need additional time, if you could just flag that for the commission at a subsequent meeting, just so everybody's on the same page in terms of timing, that'd be great. Thank you for flagging the motion issued. Do any commissioners wish to make a motion? No, to take any sort of action on this regulation. My recommendation is that we move on to the next item, but of course you have a motion. Doesn't sound like we have any interest in making a motion, so I'm going to move on to item 9. It's going to be regulation projects for 2026. General Counsel Dave Bainbridge. Good morning.
Good morning. We're still talking about regulations from 2025, and now we're moving on to 2026. I have a memo here that lays out some of the proposed regulation topics that the staff has right now. They're based on staff recommendations, commissioner suggestions, and I've indicated at the end of each one where the idea came from. I present these today to get your perspective, see what you like, what you don't like. If you have other ideas after today and any input I get, I'll bring back a schedule. We do the schedule every year mostly to put everyone on notice of what we plan to bring up this year. It's not binding. We can change it. We can move things around. We can remove items from it if we decide we don't want to go forward with them. But it's really just a good way to have a tentative schedule for the next year or so. With that, I'll briefly go through these topics. If you have questions, just stop me if you want to know more, but I'll give you a brief summary and we can always dig into more detail. The first one has to do with combining campaign filing or campaign statement filing schedules. This is an authority that we have as staff to provide advice in situations where it would make sense to combine some of the filing schedule or some of the filing statement periods. We currently do it through advice letter, but the statute actually provides that it can be done via statute. So by regulation. So we're proposing adopting a regulation that would essentially codify the practice we currently use. This happens when typically with special elections that end up having overlapping reporting periods. Our goal is always we do not permit the combined statements and circumstances where it would result in delayed or less disclosure. It's only when you would have the same amount of disclosure earlier or at the same time. And the combined statements are always optional for candidates running. They don't have to use them, but usually it's much more efficient for them to do it. So we're proposing to put together a formal process for doing that via regulation. All right, that was a long enough pause. If anyone had questions, I'll go on to the second one. The next one is updating our regulations in light of cars going into effect at the end of the year. We actually had done a package a few years ago when cars was supposed to originally go into effect. We had to rescind those as cars didn't go into effect, but we're anticipating it will at the end of the year this year. So we'll have a number of updates we need to make to the regulations because of the significant changes, the way filing is going to occur once cars is in effect. We've been working with SOS on some of these issues as we go along and flagging them for places where they need some clarification in order to build their system. So not particularly interesting, but it's going to be a lot of work.
Oh, I think it's interesting. As the Secretary of State's appointee, yeah, I thank you for working with that. I know that they have developing cars has taken longer, and a lot of that has been identifying issues and things that need to get addressed. So their regulations and how they're operating, not always regulations, but it may be forms, it may be other kinds of things. So I want to compliment you on working with them and increasing that workload, but that's really going to be critical here because I just know how much stuff has gone on and difficulty in developing the cars. I mean, it's taken what? I mean, I was part of the conversation with the Secretary of State in 2021 of saying it's not going to happen. And so we had to redo a number of things in the legislature to kind of allow for that. So I want to emphasize the importance of working with Secretary of State on this one.
Yeah, thank you. We've also been working with them on some legislation as we go along that we see needs to be cleaned up as well in order to make the law match the way the system's going to operate. Okay, number 3, this is a regulation that we're going to hopefully be able to better explain when Section 84514 applies. That's the law requiring disclaimers on ads that are generated or modified using AI. The intent of the statute is to require disclosure when AI is being used in a deceptive manner in campaign ads. But I think there's some uncertainty out there as to when the disclaimer requirement applies. So we're hoping to draft a regulation that helps to clarify when a disclaimer has to be included on an ad and when it doesn't, because AI is used in a lot of ways and it's not always deceptive. Some are perfectly legitimate uses, and some are used to deceive people as to whether an event actually occurred. So we're hoping to draft a regulation that will help to clarify that. The other piece of this one will be adding to our regulation on record keeping requirement that ads are maintained by committees. Any ad that they produce, that they maintain in their records. Currently, I would say they should be doing that anyway, but it's not explicitly stated in the regulations. So I think that would be helpful. It would also be necessary for our enforcement division when they get complaints about ads being modified by AI to be able to have access to final ad and whatever the original item was that might have been modified using AI.
Quickly, I want to thank staff for the suggestion. I think the approach that's been proposed here is really ideal for a tough situation that we're dealing with emerging technology that's constantly changing. And we didn't promulgate this legislation, sign off on this legislation, but we do need to enforce it now. We do need to, more importantly, in my opinion, educate the public as to how to comply with it. And I think that this regulation is going to allow us to do that. So I'm glad we're making this a priority. Thank you. Yeah, Commissioner Ortiz.
Thank you. We're number 3, correct?
We are.
So when it says the drafting regulation that will further delineate when the I disclaimer is required, is it going to be like the ad require 30% of AI, 30, 50%? When does it get to be disclosed?
Yeah, we're still working on that. I think our aim is going to be to try to isolate those instances where it's being used in a way that's deceptive. And when there's two different parts of the statute. If something is generated using AI completely, that requires a disclosure. The second part is if it's modified in a way that makes it,
Yeah, that's your second part of
Significantly
of your writing is, it says, things that modified using AI to help insurance. So is is a disclosure requirement when is AI used completely in the advertisement? When it's used 30%? I mean, I'm just trying to figure out how somebody I'm sure is gonna have to define that.
yeah, we're gonna work through those issues. I think the main part to know is that if it's completely used by, there are two different rules, whether it's completely generated by AI or whether it's partially generated by AI. But in the end, the statute it intends to get at deceptive uses of AI, whether it's completely made by AI or partially made by AI.
Partial will be an interesting word to apply.
Yes. Yeah, no, it's going to be tricky, and we're not going to be able to answer every circumstance where AI may or may not have been used, but we'd like to at least provide more guidance than what is currently in the statute.
I think it's important to make clear those limitations and regulations because more and more people are going to be using AI in their ads and everywhere.
Yeah, this section is 84514. And in it, the term that we're looking at is the visual or audio media is materially altered by artificial intelligence such that the alteration would cause a reasonable person to have a fundamentally different understanding of the altered media when comparing it to the unaltered version. So that's the phrasing that we think maybe needs a little more explanation.
Yeah, very clear. Commissioner Wilson.
Right, and then what does materially altered mean? I mean, that's going to be critical because somebody might say, well, I just put a hat on somebody in an ad. That's not material, even though it changes the message.
Commissioner Brandt.
I lead at the National Judicial College. I'm leading an initiative on AI in the courts. And, judges have been doing this and many are just don't want to deal with it. But it is, and we're actually looking at how it can help courts on access to justice and other kinds of things. But the thing I've seen from courts is struggling with this same challenge of what do you do? It's the obvious one is you haven't checked your cases, then you relied on them in cases. So those are the things that get the coverage. And so that's an easy thing to say. You can't just do that. You have to have read the case or something like that. So it's not about percentages. I mean, I think that's part of it. I mean, there are some courts who have considered that, but they've looked for ways to make an action, something that that's enforceable. And some ways, some courts have gone as far as saying, if you use AI at all in your brief, you just need to disclose that. And that's all. And then, they take the risk. They may find things, but that tells judges and their clerks, if they have clerks, they need to look deeper on these things and they need to check. So there are a variety of ways to do it. And so my sympathies for trying to deal with what is the standard here and listening to the language in the statute. Yeah, how do you make a judgment about what materially changes? Anyway, yeah. Okay, good luck. Thank you. This is a great one. This is a great challenge. But on the other hand, it may be kind of fun. Like, wow, this is a really mind-bending challenge. All right.
All good points here. I think it'd be helpful. One of the authors, I believe, is no longer with the legislature, but the other author is still with the legislature, Senator Cervantes. So I think it'd be worth working with her office, seeing what their thoughts are in terms of crafting this regulation. And as far as I'm concerned, I think the priority is providing as clear a standard as we can that's easy for the regulated community to follow and for the public to identify potential violations and for us to identify potential violations. Any other comment or questions on this before we move on to the next one? Okay, perfect.
All right, and thank you for all those comments. It's always helpful to hear people's opinions and thoughts. as early on in the process as possible. Okay, number 4, this has to do with the opinion that was issued in August of 2025. I think everyone was on the commission at that point. You'll remember it involved an official whose wife worked for Stanford Hospital and was city manager of Palo Alto. So they had lots of decisions involving the University of Stanford, or Stanford University. And the question was really, at what point were those two entities closely enough related as nonprofits that financial interest in one would be considered a financial interest in another? In that circumstance, the opinion from the commission concluded that they were sufficiently related that it could create a conflict. One could create a conflict for the other. And at the time, the commission recommended that we try to adopt some regulations that might help clarify what the standard is. You'll remember we have a standard when it involves for-profit businesses, but nothing similar for associated nonprofits. So we're going to attempt to draft some regulations that would help provide some guidance on that, similar to the ones that we have for business interests, with the main difference being there aren't owners of nonprofit organizations. So we'll have to come up with a little bit different way of determining when entities are related. But we had a robust conversation about that at the commission meeting. So I think we have a pretty good understanding of where the commissioners are coming from on that issue. Moving on to number.
Can I just jump on?
Commissioner Brandt?
I've said plenty in the Stanford case, so I don't need to do much. I just want to make sure Cal Nonprofits is, working in a nonprofit, I know how much collaboration there is and how much interaction there is among nonprofits in certain areas. Talk to Cal Nonprofits. They're the ones who I think they give you the best perspective, most helpful.
All right. I've made a note of our first person to reach out to. Okay, number 5 has to do with last year, the commission sponsored legislation to require disclosure of ownership interest in cryptocurrency. That goes into effect beginning with the reportings for next year. So in the meantime, we have some regulations that need to be updated just to reflect the new requirement for reporting cryptocurrency. Should be fairly minor changes, mostly just some cleanup. Number 6 has to do with SCI filing requirements for officials holding multiple positions. This was an issue that was actually brought to us by some filing officials. The legislative and the Assembly and Senate Ethics Council brought this issue to us that we're needed clarification of when an official who is an 87-200 filer who also holds other positions as an 87-300 filer, when they need to be listing those positions and filing separate SCIs. We're not planning on a change in policy, just clarifying in regulation when that's the case. And
Commissioner Zettel?
On the issue of multiple agencies, doesn't the Form 700 have a space, a line item? Are you filing for another entity? So that would cover it.
yes, it does. In some instances, an official is required they can file one statement, but they need to list their other positions. And in other instances, they don't need to list the other positions. So we would like to clarify in the regulation when they do need to list the other positions and when they don't. I think is going to be the central change. And then we'll also look to see if there's
And
other
if a
ways.
person who has to file has a question on that now, they should call for advice.
Yes, check with their filing officer or reach out to us via email or telephone.
And they can also take a look at our FPPC Form 700 materials, which are on the website. In particular, I believe our reference pamphlet addresses this specific issue. Probably can remember the exact page off the top of my head because I had to advise so many people on this. General Counsel Bainbridge mentioned that this was a suggestion of legislative ethics in the Assembly and Senate, where this issue comes up quite a bit, but it also comes up at the local level, of course, as Commissioner Ortiz referenced. So I think it's good that we're going to pursue a regulation here. So we're not just directing people to our materials online. They have a regulation they can look at specifically. Okay, thank you.
All right, and last but not least is a additional reporting requirement or clarification, depending on who you ask. It's for lobbyist employers who make behested payments. This regulation would clarify that they should be reporting those behested payments as other payments to influence on their quarterly lobbyist employer reports.
And this one's a chair suggestion. I think one of the biggest issues with behested payment reporting is just the lack of disclosure on the payor side. So I think having this clarifying this reporting piece is going to make it a lot easier for public officials to timely disclose behested payments, and not be put in a situation where they find out after the deadline that a payment was made at their behest. I'm looking forward to fleshing this out further once we bring this up for consideration. I think as far as ex parte, I should disclose related to item number 6 that, you know, I've met with various different clerks, county registrars to discuss their what they feel works, does not work in terms of our Form 700 process. This is something that came up in discussion with Ventura County, City of Ventura, as well as LA County, City of LA. It's not necessarily something that didn't work, but something that they would appreciate being in a regulation, being clarified. And then, of course, Assembly Legislative Ethics Council, Pat Fitzgerald, Senate Legislative Ethics Council, Mayor and Pat. This is something that they've discussed in the past. Anything else on this item? for
I just
commissioners?
point out in response to Commissioner Zettel, we did do a fact sheet on expanded statements specifically to address the gap of time until the regulation is passed.
Do we have any public comment on this item? No. Okay. General Counsel Bainbridge, remind me, should we make a motion to approve the calendar?
No need. I'll bring the calendar back with specific dates for these different items. I haven't heard any objections to any of them or any additional items. It's a pretty full slate. So we'll go with this and I'll bring a calendar back next month that the commission can adopt.
Perfect. And it looks like we didn't get any public comment on this item. Obviously, FPPC regulations are tremendously important and impactful. So we'd greatly appreciate public comment from the regulated community as well as good government groups. Common Cause, League of Women Voters, any of you out there watching today's meeting, if you have ideas for regulations, we would love to consider them. Please reach out to our legal division. You can reach out to me, whomever. Please let us know if you have feedback on the ideas that we've proposed and considered today, if you have ideas for other regulations. Thank you. Okay, let's move on to item number 10, our legislative update. We're going to welcome up to the podium our senior FPPC Legislative Counsel, Lindsay Nakano. Good morning, Ms. Nakano.
Good morning, Mr. Chair and Commissioners. I'm Lindsay Nakano, Senior Legislative Counsel with the FPPC. Today's legislative update will include a presentation of the 10 legislative proposals that are in the report, 8 of which I provided a general description of at the November Commission meeting. The 9th was proposed to be added at the November meeting, and the 10th proposal is also new. Before I get into the legislative proposals in the report, I'd like to brief the Commission on one newly introduced bill that would amend the Political Reform Act. This bill is not in this month's legislation report, but will be included in next month's report. AB 1560 was introduced last week by Assemblymember Tongipa. The bill would prohibit a person convicted of a crime of public corruption from acting as a lobbyist. The bill defines crime of public corruption to mean any crime listed in Section 20 of the Elections Code, which includes a felony involving accepting or giving or offering to give any bribe, the embezzlement of public money, extortion or theft of public money, perjury or conspiracy to commit any of those crimes. And the bill makes 3 related additional changes. If a person is convicted of such a crime and is already a lobbyist, the bill would void their lobbyist certification. SOS would be prohibited from accepting a lobbyist certification from a person who has been convicted of a crime of public corruption. And the contents of a lobbyist certification must include a statement that the lobbyist has not been convicted of one of those crimes. There's no questions or comments on that. I will move to the legislative proposals. There is one other active bill, and I will go over that with.
Sorry to interrupt you,
Yes.
Ms. Nakano, just clarifying. That is a non-sponsored bill, a new bill that's not on the. Go ahead.
Yes, I was introduced just last week, so it didn't make it into the report, but it will be in next week. I'll go over the 10 legislative proposals in detail that the detail that we have currently developed. I'll pause after each one if there's any questions or feedback from the commission. At the end of the presentation, I will request that the commission take a vote or entertain a vote to sponsor the 10 proposals. The first proposal would require candidates and treasurers to complete training developed by the FPPC. Not yet reflective in the draft language, completing the training would be a condition of appearing on the ballot. Staff are still considering the scope of the bill, and we do have interested authors on this proposal. At the Law and Policy Committee meeting held last week, Chair Silver expressed that this bill is a priority for him, and Commissioner Brandt provided feedback that we should be sure that the proposal is written to accommodate candidates who apply or qualify right before the election or before papers are due. We'll be engaging with the Secretary of State's office on this proposal and others in this package. Pause for any questions.
Commissioner Ortiz?
Thank you. This is a very good bill and necessary, the training. When you say commencing a candidate for elected office, any office, local, state, whatever, as long as it's a school board, anything, correct?
As we're contemplating it now, we include state and local candidates and treasurers, but we're still considering what the appropriate scope of the bill would be.
Commissioner Ortiz, if you wouldn't mind me putting you on the spot, what's your feeling in terms of scope? Do you think?
I think this is a very important bill. Absolutely. I mean, I remember Beresian, when I first elected, I didn't know a lot of this stuff. And most people, unless you have a lot of money in your campaign account and you can hire attorneys and the whole thing, but Commissioner Settler talks about the little person who doesn't have those accesses. This, training is very important. But I hope you include also local and special districts.
Thank you.
Yeah, I think the sort of situation that Commissioner Ortiz laid out, where you have a local elected, kind of similar to the situation that Commissioner Zettel brought up in terms of the amendments to the regulation of PC, where you have a local elected who's part-time, who has their own job, family to worry about. They don't have the same ability to familiarize themselves with the campaign rules, or I should say time necessarily. So I think this allows us to prioritize that for officials, really emphasize how important this may be in regards to other aspects of their position as a public official. And I think that's particularly what I'm getting at, is it's particularly relevant at the local level. Any other comments on this legislation? Commissioner Wilson?
Yes, just for clarification, Councilman Kano, in terms of city attorneys and city managers, do you know if they're required to have mandatory training under current law? Well, if not, they should be included in this legislation. is all I'm
She's
saying.
looking
General
at me.
Counsel Bainbridge?
Yes, there is ethics training required.
But how about on campaign requirements? I know they're required to get ethics training, but how about training on campaign laws and so forth?
No, there's no requirements that I'm aware of.
Yeah, because they're the ones that the local elected officials, as Commissioner Zettel pointed out, who have other jobs, they work part-time. One of the people they're going to probably consult with would be the city attorney. For example, they might go to the city manager and say, hey, what advice do you have? And if they rely on that advice, I would argue, or at least we should consider, that city managers and city attorneys should get the same kind of training that local candidates and treasurers get, or not necessarily the exact training, but comparable training. Just something to consider.
No, that's an excellent point. I think it really emphasizes the fact that of all the characters, the actors in the political process, lobbyists, public employees, elected officials, candidates and treasurers are the only folks that do not have to take a training. So, elected officials, public employees, lobbyists, they all have to take an ethics training. So I think it's really important that you really emphasize education in this area, especially in terms of city attorneys and folks that are giving advice to other public officials
Yeah.
on some of these rules.
Yes, and Commissioner Wilson, you're right. We have cases before us where a city attorney gave the wrong advice to a staff person and then they ended up paying for it. So I agree with you, city attorneys, I mean, because they go there to ask for advice on campaign issues, which they don't necessarily are trained to do that.
Thank you for the feedback.
Commissioner Wilson.
Didn't mean to put you on the spot there. It's a friendly question.
Seeing no more questions, I'll move on to the second proposal. This one is the first to be in print. SB 401 by Senator Hurtado was amended to delete its former contents and replace it with the language that appears in the report. The bill would authorize the commission to extend PRA filing deadlines for individuals who live in an area affected by an emergency proclaimed by the governor or a local jurisdiction. Staff would like to add that the commission may extend filing deadlines only if the emergency is reasonably likely to affect the ability of the affected parties to timely file. The bill was heard in the Senate Elections Committee this week and passed 5-0. It will go next to the Senate Appropriations Committee.
Commissioner Zettel? Okay. Thumbs up for the record. Any other comments, questions from commissioners? Okay, 3. Or I guess that was 3. Why don't we move on to?
Oh, that was 2.
4? Yeah. Okay, go ahead, Ms. Nakano. I'll
Okay.
let you handle
Moving on to the
agenda
next
rather than
one.
me.
Okay, this proposal would extend the time period in which filing officers are authorized to waive the late filing fee for statements of economic interests. This proposal is still in development. We're determining what period of time would be provide the most effective discretion for filing officers. So we will keep the commission updated on our conclusions there.
I think it's worth noting that when I first saw this proposal, I thought, well, this doesn't seem like something that the FPPC would sponsor. But once I dug deeper, it's pretty clear why it's good policy. That's just because it gives us the discretion to deal with circumstances where people were acting in good faith, and they could potentially be punished greater than people who weren't, based on the structure of the fines for late Form 700s. As far as the time period, I think we're dealing with a tricky issue just because, like I mentioned, a lot of the people who would be helped by this legislation wasn't their fault that they weren't able to file within a specific amount of time. Perhaps their filing officer forgot, or for whatever reason didn't contact them for a very long period of time, and then they filed immediately. We want to make sure that the FPPC has flexibility to address those kind of edge outlier cases. So I certainly support this change.
Okay, moving on to the fourth proposal. This would revise and add requirements relating to the nonprofit donor disclosure in connection with sponsored travel. These are based on recommendations from our audit division. The proposal would eliminate the condition that reporting is required only if the nonprofit's travel payments reach 1/3 of its total spending, as reflected on the nonprofit's IRS Form 990, and would retain the other existing monetary thresholds that trigger reporting. The proposal would also explicitly require disclosure of each travel payment and the name of affected officials, and would add related record-keeping requirements. We have an interested author on this proposal, and I'll keep the commission updated as that develops.
Thank you.
Moving on to number 5, this proposal relates to clarifying the limits on the use of campaign funds for travel. This proposal is also still in development, and I hope to have more detail to present to the commission soon. The sixth proposal would expand the prohibition against creating a fictitious appearance of support or opposition for or against a legislative or administrative action, a practice sometimes referred to as astroturfing. Under existing law, this applies to lobbyists and lobbying firms, And this proposal would extend the prohibition to apply to lobbyist employers as well. Lobbyist employers may be the parties who are more likely to pay for this activity. Commission staff have found research that suggests that the use of AI in astroturfing may be on the rise, and this proposal would help strengthen the existing prohibition to protect against this behavior. And we have a confirmed author for this proposal, which I think I'll be able to share at next month's meeting.
How exciting. Commissioner Zettel?
To 5 on, yeah, we're explaining campaign funds and what they should be used for legitimately. Recently, there was media concerns with one of our statewide elected officers as to why they spent $500,000 almost on legal fees. And the media still, the FPPC ruled that it was within the law, but the media still had some issues with it. I'm wondering if we need to add further restrictions or explanations on the effective use of campaign funds, because there might have been a little bit of a stretch as to where was it campaign related or not. Just take a look at that.
Staff can look into the issue and provide an update on potential proposals. I
Just,
can move closer.
do we need to have more definitions of what's legitimate with campaign expenditures?
Related specifically to legal
To
fees?
legal fees, to employment. I mean, we had another one with an employment issue of a fictitious employee that's being looked at right now. So I'm wondering if this is an opportunity for us to take a harder look at legitimate campaign expenses. And this is a great first stab at many of them. So
Thank you.
Okay, seeing no further questions or comments, I'll move on to number 7. This proposal would create a new mechanism for the Secretary of State's office to automatically terminate committees that have been inactive for at least 12 months and that reported a minimal cash balance on their last campaign statement. Process would include the opportunity for either the committee or the commission to object and stop the termination process. And process-wise, the Secretary of State would send the notice to the committee. If the committee or the commission does not object, the treasurer's appointment as treasurer of the committee would lapse after 90 days after the notice, and the committee would terminate after 180 days after that notice. And we have a confirmed author for this proposal as well. Seeing no questions, I'll move on to number 8. This proposal would transfer the duty to conduct the mandatory lobbyist training from the legislative ethics committees to the FPPC, with the training to be conducted virtually and on demand via an online learning platform. The commission would develop this training and would consult with the legislative ethics committees on components of the training that are outside of the PRA. Existing fee revenue available would be transferred to the FPPC to develop the training.
Commissioner Wilson?
In terms of this particular item, what would be the impact on staffing with FPPC? Would this have a major impact, minimal impact on our staff resources?
I wasn't going to talk this meeting.
I
But
couldn't hear you.
I wasn't going to talk this meeting, but I decided, might as well.
Aren't we lucky?
We're looking at the fiscal impact. We're hoping that this is going to be an online program that's similar to the Blackboard program we use for the prep program. So it's actually more accessible where lobbyists can take the training at any time. They're given their certificate, and then we'll figure out how to get that information to Secretary of State. So we will definitely figure out if there's a fiscal and if the cost of the training will cover the cost to the FPPC, so that we're looking closely at that.
Thank you.
Thank you. That's helpful. In connection with this training, there's currently a $50 fee that's paid by participants. Is that correct, Ms. Nakano?
Yes.
I think we would plan to keep that in place as a funding mechanism for this training, as well as a potential transfer of existing fee revenue from past trainings to cover staff costs, new technology to provide this on-demand training. As someone who did this training for 5 years, I can tell you personally, it just makes so much sense policy-wise to have this with the FPPC. We're the one charged by the Political Reform Act to provide advice on the lobbying rules to lobbyists. This would be one of the few, if not sole, exceptions to that direction in the Political Reform Act. It's also a burden on the other folks who have to conduct this training right now. Their clients are not lobbyists, so they're forced to familiarize themselves with these rules that we are in fact the experts on. And then lastly, I just think having it be on demand is in everybody's best interests. The FPPC is really devoted to moving into the future in terms of technology. On-demand training, in my opinion, is extremely effective. It's flexible. That's especially relevant when you have a requirement like in the lobbying context where folks need to take that training by a specific deadline or they're not going to be able to lobby. Also, it gives us the opportunity to require certain understanding of the rules in order to complete the course, right? So after a certain amount of time, a certain amount of slides, information presented, you'll have participants who then have to respond to questions or polls that gauge their level of attention and understanding of the rules. So I just think this is a great change. Of course.
This is a very technical question, but this $50 fee that you're referencing, is there a cost of living adjustment tied to that $50? So 20 years from now, $50 won't get you what it gets you today. So it might be something to consider if it's not currently
Yeah.
in place.
That is something to consider, and we're seeing the $50 is still the adequate amount of money, because I believe that $50 has been the same number since the beginning of when the training was required.
Just a question.
That's a very good question. And I think once we are able to identify the potential costs of developing on-demand training, other related costs, I'd be interested in how we approach that number. So, are there any other comments from commissioners?
Thank you. And moving on to number 9, this proposal relates to the use of campaign funds for security expenses. This proposal was proposed at the November meeting by Commissioner Zettel, and my apologies for misattributing this at the law and policy meeting. Existing law permits candidates and elected officers to use campaign funds to pay for certain security expenses, including expenses for providing personal security. This proposal would clarify that campaign funds may be used for security personnel only if the security personnel is appropriately licensed by the Bureau of Security and Investigative Services.
Excellent. Well, Commissioner Zettel, anything?
Thank you. As a former director of the California Department of Consumer Affairs, I think this is very appropriate. Thank you very much.
I agree. I think this is important change. I think it's critical that public officials, elected officials have access to resources necessary to protect themselves, given what's going on right now in the political process in the world. However, we want to make sure that it's done with safeguards in place that guarantee against abuse. So this is an important step towards getting there. Okay.
Okay, moving on to our final proposal, number 10. This would require additional detail to be reported about an expenditure when a candidate-controlled committee supporting a candidate for elective office makes aggregate expenditures over a certain amount to a single recipient when the candidate will not be listed on the ballot at the next election. This additional detail would be included on the semi-annual campaign statement and is designed to give the public more information about larger expenditures during periods where we may not usually expect significant expenditures.
Any comments or questions from commissioners? Commissioner Zettel?
It addresses my previous comment. Thank you to some degree. Thanks.
Okay, thank you, Ms. Nakano.
Thank you. And if there is no other discussion, I would respectfully request that the commission entertain a vote to sponsor these proposals.
Okay. Do we have any public comment? No. Then I'm going to go ahead and make a motion to sponsor proposals 1 through 10 in the legislative update. Do I have a second?
Second?
Ms. Vo?
Second.
Yeah.
Okay.
May I make a comment? I want to thank Commissioner Brandt because he looked into this issue and interviewed a lot of people, probably spent a lot of time and effort. And congratulations to you. It's going to be heavy lifting and a lot of work. So thank you.
All right, Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson, Commissioner Zettel,
Aye.
Chair Silver,
Aye.
motion passes.
And I echo Commissioner Zettel's sentiments in regards to Commissioner Brand as well as Ms. Nakano. I haven't looked at the records, but 10 sponsored bill proposals. That's probably a record by a mile. So good luck.
Thank you.
We're going to be there to support you through the whole process.
And thank you.
Okay, let's move on to item number 11. That's going to be our executive staff reports. We'll start with our chief enforcement, Kendall Bonebrake. Good morning again.
Good morning again. This report from the Enforcement Division is as submitted, but I wanted to take just a few minutes at the beginning of 2026 to commend the great job that the team did in 2025. I wish I could take credit, but since I've only been there 4 months, it truly is the team that has been there in the Enforcement Division who has completed such a great job in the past year. Just to point out a couple of numbers here, 902 complaints processed by the team, 1,729 referrals processed, and 1,268 cases closed. Also ending the year with an open caseload of 856. This number maintains the amazing work that the Enforcement Division has done over the past several years to reduce its caseload significantly. And this number maintains that lower caseload. So very proud of the team. I want to thank them very much for everything they've done and point that out to the commission today as we start a new year.
Excellent. Thank you. I'd like to take this opportunity to highlight some figures as well. I'm looking at your executive report, and it looks like we levied fines of $543,539. The reason I'm so exact about that is because that's going to be the most that we've levied this decade in off an election year. That's a really significant number, and the Enforcement Division should be proud. And they did that despite having 1,300 new open cases and still keeping that number, like Enforcement Division Chief mentioned, under 900. And again, I mentioned earlier, that's a 40% drop from just 3 years ago. So congratulations, job well done. Thank you, Enforcement Division.
Thank you.
Thank you. We have our audits report. Ms. Shaw.
Good morning. My report for this month is as submitted. However, I do want to highlight that we had our last public draw from last year in December. The results have been posted on our website, so they're available for everyone to view. And the rest of the report is as submitted.
Excellent. The draw itself, it can be viewed on YouTube.
Yes, the link is also posted on our website.
Excellent. Thank you, Ms. Shaw.
Thank you.
Let's move on to Legal Division. General Counsel Bainbridge.
Down here. I just wanted to mention that we have our new major donor and IE prep course that's going to be launching. So this is the 5th course now from the prep program. So a new category of potential minor violations where people will have an opportunity to get educated rather than get fined. This past year, we had 266 people graduate from a prep course, which was the highest number yet, and should have hopefully more next year with the additional program. I would, not to sound like I'm copying Ms. Bonebreak, but also like to commend all of the legal division staff for all their hard work in the past year. You'll have the annual report that I believe you'll get a presentation on here in a few minutes, which has our specific numbers. But as always, lots of advice provided quickly and of high quality, and that's credit to the staff that do such good work.
Excellent. Thank you, Mr. Bainbridge. I'd like to thank Legal Division for all their hard work. They did a particularly good job on responding to the special election this past year. That kind of came out of nowhere. It was amazing how quickly that they were able to get the filing schedules together and accessible to treasurers, candidates, etc. And other materials. Last year, we developed materials for the LA wildfires for public officials down there in terms of Form 700 compliance and vested payment compliance. So just an excellent division, responding quickly and accurately and well. So thank you to the legal division. Why don't we move on now to Administration and Technology Division? Dr. Ju Wang, good morning.
Good morning, Commissioner and Chairs. So the Amherst report submit as it is, but I do want to mention, so starting at the beginning of this week, 2025 annual notification has been sent out for both April 1st filer and March 2nd filer. So we're still working on SBA 52 filer who manage public investment fund. So we anticipate approximately 3,000 new filer will be added into the system. So if you're SBA 52 filer, you haven't got any notification from our system, thank you for your patience. We're processed by batch. So hopefully by the end of this week or next week, everybody can get the login credential and annual notification. So this is our second year for mandatory e-filing. So we have created a lot of material which are available at our website, which include how to expand the statement in our e-filing system. And for the filing official, how to add the candidate in our system. So we hope the filer and the filing official find that's useful. But if they have any question, anytime, send an email to the Form 700 email box. And hope this another successful year.
Excellent. Thank you to you and your staff. If we haven't already, if we can make sure that filing officials are aware that additional notifications may be coming in regards to public officials who file with us, who file because they manage public investment.
Yes, we are going to continue sending our monthly newsletter, which will include all the useful information for filer and filing official.
Excellent. Thank you so much. Okay, now I'm going to throw it over to our Executive Director, West.
Hello. So it's the January meeting, so you get to hear some special presentations. And our first one will be by our Executive Fellow, Josh Donner.
Good morning, Mr. Donner.
Good morning, Commissioners. Good morning, Chair Silver. My name is Josh Donner. I'm an attorney and an Executive Fellow at the FPPC. 2025 was a great year for the Commission. I want to add praise for the Enforcement Division. I don't want to reiterate too much that was stated already. The only other detail I'll add is that 878 cases were successfully prosecuted. These aren't minor paperwork issues. These are campaign money laundering, mass mailings of public expense, conflicts of interest, and a series of violations of campaign finance and ethics law. For the Legal Division, I'll give some numbers that Mr. Bainbridge mentioned. More than 6,200 emails providing advice on compliance with the Act were given this year. 169 advice letters were researched and offered, and 58 of those related to Section 1090 of the Government Code. All of this is available in the lovely packets that you were provided earlier this morning for our annual report. For policy, this was a really good year. We reached a high water mark 6 sponsored FPPC bills were signed into law, which is the highest in recorded memory. Some of the larger bills, AB 953, blocking foreign influence in ballot measure campaigns, AB 1029, bringing crypto and digital assets into disclosure and conflict of interest law, making sure that our regulations are keeping pace with the future. For crisis response, we delivered when it mattered most. When Los Angeles was hit with deadly wildfires, the commission showed up to assist all public officials with their campaign filings, because in a time of crisis, we want folks to be focused on their jobs. We don't want folks to be worried just about making the choice between saving lives and complying with their statutory requirements. The commission provided clear guidance, flexibility, and support. And this is what a modern ethics agency should do: enforce the law and help public servants in a crisis. For technology and election integrity, we've been forward-looking. It was a turning point for how we regulate campaign technology. We adopted new rules for third-party processors used by campaigns to address verification, restrictions on prepaid cards, identifying foreign IP activity, more future-facing, ensuring that we are having fair and honest elections. These are direct ways to target how illegal money enters our system. And the commission also convened a panel on AI and campaign advertising. We brought together experts on how to detect manipulation and deep fakes. We'll be continuing that into 2026. For leadership and governance, the commission proudly welcomed 2 new commissioners, Commissioner Brandt and Zettel. Both bring deep experience, particularly on the legislative branch, that will be very useful for the commission going into the next year. Looking ahead, going into 2026, the message is clear: strong enforcement, modernized regulation, and serious transparency work. The commission isn't just keeping up with our political system, it's shaping it. And was proud that I get to speak to all of you today.
Well, thank you, Mr. Donner. Any questions from commissioners? Any public comment on this item or any other items that were on the executive staff reports? Executive Director West.
Yes, so you all will get a copy of our annual report, and I encourage you to read it and look at the wonderful illustrations. The only thing I would point out is we have done so much outreach this year that we had to do a couple articles about it. So enjoy, and there's your paper copy. It's also, for those of you listening, it's on our website. So please download and enjoy the links that work, and it's a wonderful labor of love. I want to thank Riego Vasco and Davina Vo and Josh Donner and Lindsay McCano and Sherry Yang. I mean, there were so many people that worked on this. So really want to thank everybody in the staff that got this done so we could hand it out at our January meeting. So yes, yay.
Thank you again.
For those of you listening, it's the huge crowd that's here that's clapping. So last item to be presented, I'm going to invite Sherry Yang, our communications officer, up, and she's going to talk to you about our updated heat map.
Great.
Hi, everyone. So I get the opportunity to talk about something really fun and exciting. So if you look, I think it's on your screen, but if you look down, you'll see that we released our 2025 enforcement heat map this month. This lives on our website. And, oh. Okay.
Got it up.
Okay, and then what would be the URL? Looks to me like fppc.ca.gov/transparency/heat-map1 If that's too much for you to remember, it's very well highlighted on our website under the transparency portal.
And it's on the agenda. You can click on it. There's a click right on the agenda.
Even better. Good point.
All right.
Okay,
There
we're
it
gonna
is.
throw it
There
back.
it is.
Yay.
Yeah.
Technology.
Yeah.
Yay.
So when you open it up, you'll see a map of California with everything organized by county. You hover over this, let's say like Placer County or Yuba, or let's do Butte County, you'll see everything that's included, which is what kind of violations that were involved, how much was fined when the case went to the commission, and who the respondent was. You'll also see their position and title up here. If someone was on the ballot that year, you'll also see whether they were successful or unsuccessful. But if they weren't on the ballot, it shows their title, just their title. And then you can click on the case name and it will pop up with a PDF so that you are getting the actual PDF, the stipulation decision and order. So you're not just looking at the summary, but you can read the real document itself. So the point of this heat map is just to make our enforcement work more visible as well as easy to access for the public. We've gotten a lot of really good feedback on this from the public. We talked about it yesterday at our meeting and people thought it was really cool. We also clicked on their own county, so they got to see what was going on in their own county. So yeah, if you guys have any questions, let me know.
Commissioner Brandt?
So thank you. I love this map. The thing I'd like to suggest is that LA County, which is where I was born, you know, it's often seen as LA, that's the city and that kind of thing. LA has 88 cities, has hundreds of water districts. It has mutual water companies that are not subject to our act. So having worked for a member from Los Angeles County, from the Southeast, I know the challenges of small cities and those kinds of things. So I think I'd like us to think about, I understand we may go to Los Angeles in this next year. And I think maybe there's an opportunity for us to think about this. Is this kind of really brought it home to me? Maybe we do something more than just meet. Maybe we do things, maybe we do an initiative with local press, you know, with and invite more than the LA Times, you know, and reach out to them, but not in a negative, oh, you know, this county's been horrible. You know, it's about, you know, this county has a lot of challenges because it has all these, and there's not the time. You know, Angelinos don't county. Anyway, don't have the time. You know, these are hardworking people who don't have the time to follow what's happening at their city council. And so we're there, but maybe there's some public information. I don't know what that is, but it's just a thought about, because I love this map. I just thought, oh my gosh, you're right. But on the other hand, coming from Los Angeles, I understand the challenge of all those and working with. I mean, we had 9 cities in our assembly district. It was just a challenge to stay on top of all of them, just for us, just for those 9 cities. And so I think that public attention to this and the opportunity, pay attention to your local officials. They're trying to do a good job. And, you know, and there are some problems, but, you know, maybe public attention will help bring attention to that. And they won't feel like they have to do things that are not provided for in the law, shall I say, because the public's engaging. So I don't know, it's just a thought. I'm just wearing my political hat. Anyway, thank you. Love this map. Thank you.
Thank you for your comments.
I mean, that's a great point, Commissioner Brandt. I love this map too. I don't know what that says about us.
We're visual learners.
I guess so,
Yeah.
but I agree. I think it's you know, it's not only a tool to show the public that we're enforcing the law, where we're enforcing the law, where these violations are occurring for enforcement, but it's a way that we can take a data-driven approach to education, right? We can see these are the areas where clearly, or it appears that there needs to be more education, whether that's seminars, whether that's resources that are tailored specifically to the kind of situations that come up there. Maybe it's an opportunity for us to engage with filing officers in those jurisdictions to see what we can do to reduce these types of violations in the future. So I'm really glad that we're doing this.
And dare I suggest, maybe we don't meet in the city of Los Angeles. Maybe we meet in the San Gabriel Valley or somewhere else. You know, there are lots of places there. And because I think sometimes the city of LA, and I have to admit, I was born in the city of LA and I worked for the city of LA and I had those things. But having worked for a member that didn't represent any of the city of LA, I understand that they just don't get attention. And so maybe this is an opportunity for us to go to somewhere in San Gabriel Valley or, something like that. I have no idea. Or the Southeast, although they're really hard to get facilities in the Southeast. So yeah, that's a challenge. I mean, there are city council chambers, but they just don't have the funding to do this, and thank you, City of Chico, by the way. So anyway, sorry, I'm talking too much. Just love this idea.
Thank you. Commissioner Wilson.
No, I think Commissioner Brandt's point is an excellent point. I mean, the largest delegation of elected officials in the state legislature come out of LA County. So it makes total sense to focus on LA County, even for those of us who were not born.
Some of us ran track there, though. You'll have to, for those watching, you'll have to look that one up online. Any other comments or questions on this item? Anything else?
Thank you.
Ms. Yang?
Thanks for your comment.
Well, thank you. And I want to thank NPR Sacramento again for covering the heat map last year and highlighting how successful we were in terms of enforcement and education. Thank you for their interest. And of course, if they want to highlight it again this year, Ms. Yang would love to
Yeah,
hear
we
from you.
would be welcome to. Yes, our heat map and our prep program have both been highlighted nationally by the Campaign Legal Center as accomplishments. I want to thank Carly Haug and Rieko Vasco for the heat map update this year. And I forgot to thank Jay Wairenga for the annual report. So I just want to make sure I get all my shout outs in. And just one final update, as most of you know, we did outreach yesterday where we had a community meeting and staff all came. You see all the staff here, and we all came to tell them what's going on with the FPPC, to build relationships with the local filing officials, city attorneys, county councils. And we got good participation, good feedback. We're going to have their help on a couple of the regulation ideas that affect them. They're going to give us some input. So it was a really successful meeting yesterday, outreach in Chico. So anytime we do a traveling meeting, we try to do a community outreach meeting the day before. And it's always been pretty successful. So when we go to the LA area, then we can do one down there as well. So we probably will be traveling once more this year.
Excellent. Well, thank you so much, Executive Director West. I think the one person who hasn't been thanked enough in regards to all of this is the person who keeps the trains going on time, and that's you. So I'm sure that's not who you were thinking of, right? Because you're never expecting that sort of thanks and gratitude. You basically just believe in the mission of our agency, and I think that's the only reason you show up before everybody else, leave after everybody else, and work so hard. So it's an amazing result in every aspect of the agency. So we want to thank you as Executive Director. Are you gonna cry? I'm just kidding. Well, happy birthday. She doesn't accept gifts, Commissioner. Is that all? Yeah. Oh, there we go. Okay. Yeah. More like it. Okay. Well, thank you, everybody. The last thing, I don't know if we were going to touch on this on the next item, but we attended COGL, which is an organization of ethics agencies across the world, really, Canada, United States. I remember last year we had people at the conference from South Africa. So this year we participated on a whole lot of panels, but the person who's more familiar with that than me is Executive Director West. I'll let her touch on that really quickly.
Yeah, COGL is the foremost agency, nonprofit on governmental ethics laws. And it's a North American agency that's also touching on international. So we have people from Ireland, South Africa, other countries, but it's primarily a North American organization. And our staff did a wonderful job this year. We were on many panels, had lots of participation. Lindsay Nakano and Chloe Hackard were on the planning committee for it.
I was the president this year, and we really represented FPPC in California and got so many contacts, learned so much. We get really great ideas for legislation, regulation, things that we can do. We make connections. The chair is connecting with other agencies that are also trying to figure out what to do with AI and how to improve efficiencies. So it's a really great organization that we're considered one of the prominent agencies, because some agencies are one or two people for their whole jurisdiction. So we try to give as much advice and assistance as we can provide. And it was very successful. Everybody was on a panel. Everybody was at different events, and it was very successful in Atlanta, Georgia this year. I'm going to Denver, Colorado next year, because we only go where it snows, apparently in December. We don't want to be accused of having too much fun.
Any other comments from commissioners? Okay. Well, thank you again, Executive Director West. Let's move on to item number 12. And that's going to be commissioner comments and proposed future agenda items. Do we have any comments, proposed future agenda items? Okay, do we have any public comment for suggestions for those? Okay, then I'm going to move to adjourn. Have a second? Okay, Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz, Commissioner Wilson,
Aye.
Commissioner Zettel,
Aye.
Chair Silver.
Aye.
Meeting adjourned.